So the question still remains and faces our embattled Chief Justice. What's next for her, knowing that she's suffering yet another major setback in her attempt to halt the entire impeachment hearings against her? Here's a sense of how Gertrude Torkornoo has traveled in terms of her legal battles, right? Because there's a need for us to paint that picture and to give you a sense on the number of times, not just her, but a number of individuals have also tried to support her in stopping the entire petition. Here's the point. Starting from April 22nd, where the Chief Justice was suspended by President John Dramani Mahama for a 28-day period after the petition. The suspension we know would, of course, be prolonged because of the hearings that are currently going on. And that will definitely last until the final determination is made. On May 6th, the Supreme Court dismissed the injunctions that were targeted at halting the removal process, of course. We recall that, of course, part of the process was also involving the former Attorney General himself, who then stood up to defend the embattled Chief Justice. Then on May 15, we know that another suit was filed over the constitutional breaches in her suspension. All of these issues came up, but none were successful. On May 20th, of course, Theodore Attack-Quartey was the next individual to join another attempt at halting the process. That also did not succeed. And then we can talk of May 21, where the Supreme Court then took that final decision to move all these cases off its desk, because clearly by a 4-1 majority decision, the court had then thrown away all the 2 cases pending before it. On May 21, the CJ then filed another suit restraining or targeted at the members of the committee herself, where she, of course, made a public pronouncement on what she feels about the entire removal process, which she claims has been fraught with a lot of unfair practices. All of these issues did not yield for the embattled Chief Justice. And here we are today again with this latest from the High Court and the implications of what it will be for her, yet another massive blow for Gertrude Torkornoo. So what's next, and what should be her next steps, if any? And what should we be doing as a nation, knowing that there's a desperate call from this statesperson asking to be heard and to be heard right? Joining me now, Martin People is a private legal practitioner. He's joining us via Zoom. Justice Abdullah is a law lecturer and private legal practitioner. They're all joining us, well-known faces. And of course, they've all been following the case. So makes that a simplified process for us, isn't it? And I want to pick up your thoughts, lawyer Martin People, first off, as to what you think about this latest decision. Abuse of court processes. That's what the conclusion the court is arriving at. What does it mean legally when a court makes that pronouncement? And for many who are out there asking what the implications are, what do you have to say to that?
The reports we have, it means not just the abuse per se, but the other part of the reportage that the court has no jurisdiction, meaning that the court didn't go into the merits of the case. So the court didn't delve into it. The issues she's raised, the court didn't look at them. That's chief among them is to say Shining Stars is not legally incorporated. That's to say Shining Stars does not exist as a legal entity. So it should not be able to petition for Chief Justice Torkornoo's removal. All that. The court says, no, I don't have any mandate to go into it. Okay, I'm not dealing with it. So it means that the court has not gone and decided that they are right, Chief Justice Torkornoo is right or wrong. No, what the court is saying that I don't have the power, I don't have the remit. It's not within my scope of duty to make such a determination. Okay, and so by coming here, you are abusing the court process. So you are using the wrong forum. You're worrying us. This is not the right place. Okay, so now, Blessed, what I can say is that that ruling is new learning for some of us. There were a lot of us who thought that, oh, yes, the High Court could go into that. Okay? But now that the High Court says, no, I'm not the right forum, I'm sure the Chief Justice may decide to go for it to attempt to find out the right forum. And look, to be very honest, if they do, or even if she doesn't, this is new learning for us as lawyers. This is new learning because there were a lot of us. I also thought, oh, High Court could go into it. But from what the High Court is saying, meaning that for it doesn't want to delve into this matter. It should be the Supreme Court. I guess so, because if the High Court can't deal with it, then it means go to the Supreme Court. So it's new learning. You see, this area of the law has not been tested. I mean, many aspects of it has not been tested. When it has been properly tested, the courts will indicate so. So I'll tell you a famous example is Article 181. That's if government is entering into a contract with an international business entity. When the Supreme Court dealt with the Wyoming, Isofotone, etc. cases, and they thought that they had explained the provisions enough, they wrote it expressly that, look, we finished explaining this provision. Henceforth, if anybody has a problem with this article, you can go to the High Court. So perhaps with this, maybe we will get to that threshold when the Supreme Court gives a number of decisions concerning Article 146. Then perhaps the Supreme Court will now expressly decide or direct that henceforth, if you have a problem on XYZ, maybe you go to the High Court. But for now, we haven't reached there. The High Court says it cannot. This is like, if we say a common way of putting it, it's above its pay grade or its pay scale.
Yeah.
This matter is above my pay grade. I'm not going into it. That's essentially what the High Court said.
Okay, if this is anything to go by, that will leave the embattled Chief Justice with one option to perhaps head back to the Supreme Court, correct? The Supreme Court has made its decision and pronouncement on this matter, but constitutionally speaking, you agree, they could vary from their previous position. Would you urge the Chief Justice to take another shot there?
Urge for now would be a strong word for me. I know it's mild in certain contexts, but Efo Kofi in this context is strong for me. Strong for me because, you know, from day one, I belong to the school of thought that thinks that the Chief Justice should be given a dignified exit. She should be allowed to resign. Notwithstanding that I know some Supreme Court decisions, Paul Lutadere, and then which are is it Frankie J. Chum? No, there's a High Court Amwako case where the Supreme Court said when they start the process, the respondent, that's in this case the Chief Justice, cannot resign. I'm hoping that somehow there should be an exception. So for me, I don't have an appetite for litigation on this matter. I wish that the Chief Justice could reach a political settlement with the president and other stakeholders so that she exits in a dignified manner.
Do you see that? Do you see that in her posture? She's heading now to the ECOWAS court, for instance, and look at the demands she's placing on the table. I believe somewhere $10 million in settlement. Do you feel all of that could be part of a politically negotiated process?
Oh, absolutely, yes. That $10 million will be thrown out of the window in seconds. No, it's because perhaps that avenue to resign is not available to her. That's why you see that, okay, then she's going 9 miles. So in this context, I once again implore our senior statesmen to come together and then perhaps approach her. And if she consents, then they will approach the president and the other stakeholders so that they negotiate something for her to go, so that she resigns. That would help us because, you see, right now it appears, looking at our state of development, we are not quite there. You know, the matter she's thrown out, you see that she's forced certain conversations that ordinarily we wouldn't have. You see, she raised issues of bribery, issues of nepotism, issues of political influence, matters that usually we hesitate to hold frankly in a no holds barred fashion. These are matters that when it comes to the judiciary, we are coy, we are shy about them. But I see that she's forced the conversation. And well, that's my opinion. I'm thinking that all in all, yes, she started a conversation to a certain extent. It's okay for now. I think a political settlement where she exits in a dignified manner is better. Blessed, Efo Kofi, let's mention expressly. This Article 146 proceeding she's facing, if she loses the case, look, it means that her record is tarnished. Can you imagine she, her family, her children, her record is tarnished. And besides, she will lose her entitlement because that is misconduct. When it comes to, when you look at Article 146, it's misconduct. And you see, usually in our employment law, when a person is dismissed from office because of a misconduct, that person loses entitlement. And so it means that, by her position, Chief Justice Torkornoo would have retired on her salary, entitled to security, entertainment, etc. All those things she won't get if she loses this case. So I'm thinking that perhaps if she's allowed to resign and then she can go with these benefits, it will help the whole nation.
Your final take on this, the point about the political resolution. President John Dramani Mahama will be very instructive in that process. But even before the hearings began, the president did not seem to take it lightly when he claimed that the embattled Chief Justice had gone out into the media circulating details of the commencement of proceedings. The president was clearly not happy about that and put that in a statement. Do you feel that the president, and knowing him very well, perhaps might want to take a different posture now, sit down at this point and listen to the embattled Chief Justice?
Oh, absolutely. Absolutely. I think generally, John Mahama comes across as a very amiable person, always smiling, all right? And so he usually exudes a spirit of reconciliation, friendliness. I'm not the only one saying, because he laughs, often in public, yes. So that's the reputation he carries as being amiable, being conciliatory, etc. Right? Yes. We all know the things Akufo-Addo did to him when he was in opposition, didn't allow him to get his benefits on time, etc. But it doesn't appear John Mahama is paying Akufo-Addo back in his own coin, and so many other things. We could go on and on. So the key thing is, I think some statesmen need to get up and intervene by themselves. They should approach the Chief Justice, talk to her. If she agrees, then they will approach the President Mahama, and I'm sure something can be done.
Okay, yes. Let me bring in Joseph Dindiok-Penka, who is a former Deputy Attorney General, also joining the conversation now via phone. Thank you, sir, for your time. So you've heard the latest. Do you feel it's all over for the embattled Chief Justice? In the words of the former member of the National Council of State, Samuel Okudzeto, he believes that, once the process has been triggered, it's all over for the Chief Justice.
I have. Thank you very much, first of all. And thanks to your cherished listeners and my brother Martin Pebo on the other side. Good evening to you. I'm opportune to be called upon to make commentary on this matter. And quite frankly, since its start till date, I have not commented on it because I've had other things to do. But this is the position I want to espouse. You see, she's done all that she can to stop the process of the investigation, to vindicate her right and all that, anytime she hits the rock. So, yes, you are asking me to comment in the light of that and what the Venerable Okudzeto has said. You see, for me, I have spoken to other platforms and I've indicated that the process in Article 146, which is being strictly adhered to now, will lead to one and only one inevitable conclusion, namely that they will come to the conclusion without any doubt that indeed there was misconduct. If you look at the way the trajectory of events is going, that's my opinion. And so, yes, if we are going to rely strictly on Article 146, it may just be over for the CJ. But she's trying other means, democratic, other means of vindicating her right through the processes of the court. when I actually read the reliefs that she sought at the High Court, I had my reservations because, you see, most of the reliefs she was seeking at the High Court were released before the Supreme Court. And so that clearly is an abuse of the court process. So when I heard a pronouncement by the learned justice that indeed what happened was an abuse of the court process, I just couldn't but agree with the learned justice entirely. So she also thinks that before the Supreme Court, she may not get the required justice, or before the committee, she may not get the required justice. So she's exploring all avenues. She's gone to the High Court. She's not been received, in a manner that she expected. She's at the ECOWAS Court, and she's still expecting some decisions by the Supreme Court. I want to beg to differ a little from what my learned brother Martin Kwebu is saying.
Yeah, Martin is calling. Martin is calling for a political settlement.
That is what I said. I want to beg to differ. You see, we are living in a democracy, and we know that our values as a people, in terms of our judicial pronouncements, are a guide and precedent for future decisions. So let us take a decision on this matter. Let the committee share the matter to its conclusion. Let the results be out. Let the verdict get to the public. Let justice be served, and let it be a guide for future. What he's talking about, negotiated settlement, is something he's thinking is in the interest of the TJ. But she's the one who is facing the bullet. And she says that this is the route I want to take. Right. I do not want that particular one that you are suggesting, that I go for negotiated settlement. I want to use the legal processes. Even though in a number of times she's hit the wall, she's had to lose a number of decisions by the Supreme Court in terms of interlocutory applications, and now by the High Court in terms of the originating motion that she actually filed. But the fight must continue for posterity's sake, that when a final decision is made and her rights are vindicated, it will be a guide. And when the final decision is made, she loses and she is actually removed from office for misconduct and stated misbehavior and etc. It will serve as a guide.
Okay, but how do we reconcile your point then when you say that the writings are on the wall?
You see, that's what I'm saying. I'm saying that assuming that what I have even said comes to pass, that will serve as a guide. And I'm saying that it will serve as a guide because if we don't do it to the conclusion for it to guide us, every time a process like that is triggered, then we will have to go for the other option he's suggesting, negotiated settlement. We may never have a guide in our lives. And I'm telling you that what Martin is saying, there may be some wisdom in it according to his thinking. Because what I'm afraid of is that tomorrow, another Chief Justice may be in office, a new government will come, a frivolous application is brought, the Council of State goes through it and says, look, a prima facie case has been determined, a committee is put in place, the person is removed from office. So it becomes like a cyclical kind of behavior in our democratic dispensation, that anytime a new government comes, they find something to remove the Chief Justice, so that we play political chess with the very institution that dispenses justice. And for me, I'll say that if we reach that stage, then our democracy has come to an end. Because the only institution of state, even when there were unfortunate days of coup d'etats and etc., the only institution of state that was not disturbed was the judiciary.
Right.
And for us, in a democracy, to now make the judiciary a political chess and ball game, and I have stated it in another platform, that look at even the constitutional processes for the removal of His Excellency the President and the constitutional processes for the removal of the Speaker of Parliament. Very laborious and cumbersome and difficult, near impossible. And look at the processes for the removal of the Chief Justice. Quite easy, if you ask me.
Yeah.
So I'm saying that we need to do a delicate balance. Otherwise, what we are doing today may come to haunt all of us in future and throw us asunder.
Great point here.
Very careful.
Interesting points.
Because even within a minute, even sometimes it is the case that you can give fidelity to the law, and yet mischief will be occasioned. So people are talking about the fact that constitutionally 146 is being adhered to. No doubt about that. You can give fidelity to the law and still cause mischief. And I've stated this time and again. Because if, for example, I'm not saying it is the case, but for example, I am a president and the members of Council of State, 95 to 98% of them are members of my party who have come to advise me. And I send a matter to them and I tell them that, look, I appeal to them individually behind closed doors that, look, make a determination of ABC. Do you think they will say no? But they will do it.
Yeah.
And then when it comes back to you, you approve. And the person is gone. I'm saying that no president will be in power forever. When there's a change of government, another government that comes and intends to remove the Chief Justice will create mischief, bring up frivolous and stamp up charges, and go through the same process. Since there is no legal challenge that you can mount to challenge the president's removal after it has gone through the other processes, that will be it. And that is how we are going to dance around for the rest of our democracy, and that will be dangerous indeed for us.
I'll move on to Lawyer Abdullahi, but Lawyer Abdullahi, just hold on for me briefly. Let me take the comments from Lawyer Martin Kpebu, if there are any, on the challenge being raised now by Lawyer Kpemka.
Well, Kofi, there is not much I can say to that. Yes, so you see, that's the beauty of the law. So I see what he means, that, okay, due process, let the process run its course. Yes, some people believe in that. So it means that we'll leave it at that. Let's see, as time goes on, we'll see the general consensus, whether citizens believe that the case should run its course or they want the political settlement.
He's speaking about posterity, the fact that there must be a laid-down procedure so that next time that will serve as a cardinal point for us.
Oh, obviously, that is not lost on me. I looked at all of that, but because there isn't time, I couldn't have gone on. You know, usually when we come on these interviews, it's a few minutes. I looked at all of that and still came to the conclusion that I prefer a negotiated political settlement. I looked at all of that. I'm still of that opinion. You know, you see, like Okudjete said, it's obvious. Chief Justice Torkornoo is not coming back. We will not play ostrich. You see, Okudjete said it. So many other people have said it. She's not coming back. So why don't we do it in a more dignified manner? Yes, dignified, so that she can go with the benefits. And also it will be a lesson. You see, in terms of precedent, the fact that the gavel doesn't finally come down on her doesn't mean that it is not a precedent. There will be a precedent in terms of what Lawyer Kpemka is asking for. The precedent will be that, look, for these and these allegations, eventually the Chief Justice resigned. So it's also a precedent. So when the next occupant comes in, she will be he will be very weary of things like that. You know, the various things they've said. Buying tickets for her daughter when it shouldn't be, allowing the daughter to travel with Chief Justice. Hey, let me not go into the merits. I don't want any contempt of court, though she has gone into it. But let me stop before I get contempt slapped on me.
I was going to remind you about that anyway.
So that's it.
Okay. Justice Abdullahi is also joining the conversation. And Counsel, you've heard your two fellows also talk about varied points on what the Chief Justice should be considering at this point. Where do you stand on this?
And my deepest regards to my colleagues that I haven't met for quite some time. The point about this conversation is that listen to the Chief Justice herself, you come to the same conclusion that my brother Kpemka arrives at, that she prefers to, as it were, use her case as a precedent for posterity. And so if you listen to her, she tells the members of the judiciary that she's doing what she's doing for them and not necessarily for herself. Now, that clearly tells you that she's determined to run the entire course of whatever legal processes that may be available to her. Unfortunately, for all of us, the only two legal forum fora she could explore are the High Court and the Supreme Court. And she appears to have exhausted her position up to this point. We do not know what new measure or new suit she could bring, and then with any other release that may be completely different from the ones that were having determined already. But to your earlier question as to whether, as to the implications of what the High Court said, I think my colleague Penga attempted to respond to that easily by explaining that the moment she went to the Supreme Court on a human rights matter, that was a completely no-go. And it was not surprising that the Supreme Court threw her out because per our laws, the Supreme Court is not meant to determine human rights matters. It is for that reason that she came to the High Court substantially on the same relief that she sought at the Supreme Court. But unfortunately, the law is also that a matter that has been determined on cannot be determined in another court. So this is where the issue that you referred to earlier as an abuse of the court process emerged from. So it's like the two doors have been closed on her, but those are only the doors in respect of the human rights issues. So it means, in effect, she could always come back, except that whatever she comes back with cannot be couched relating human rights issues. It has to be couched differently to be able to, if you like, invoke the appropriate jurisdictions of the court that she may attempt to go to. So these are options that are available to her on the table at this point. But outside of that, there may be great difficulties. Now, having said this, we need to recognize that whatever is playing out at this point should not be interpreted to mean that the committee is a robot seated there to do the bidding of the president. I would like to be very open-minded about the committee. I would like to believe that based on their credibility, they are going to look at matters with open-minded and fairness, and that they are not going to be mischievous, targeting the CJ simply because, and let's be reminded that simply because the Council of State found her guilty does not automatically mean that the committee would also find her incapable of continuing in her office and, as for that matter, recommend her removal. Let's not pretend about that.
All right.
It is arguably true that based on the political posture of the events unfolding, one could easily assume that the outcome is going to be adverse against her. But that would also mean that we do not even respect the members of the committee's intelligence, that they cannot see through right and wrong.
Yeah, interesting point there. Yeah, interesting point there about the composition of the committee itself. And Lawyer Martin People, let's look at the committee and its work so far. It's supposed to be in camera, but already the embattled Chief Justice has cast, I should say, her verdict on, what she thinks about the composition of the committee and the kind of individuals who've been appointed there. Do you feel that that would taint perhaps whatever outcome we'll be seeing going forward? Lawyer Martin People, I'm asking about the composition of the committee and the concerns the Chief Justice has raised. Lawyer Justice Abdullah is pointing out clearly that we should not conclude that, of course, they would come out just as Lawyer Martin, Lawyer Kwemka is pointing out that it will lead to one conclusion, that they would find the Chief Justice guilty. It could be otherwise. But the Chief Justice herself appears to have a challenge even with the composition of the committee.
Evo Kofi, briefly, I was supposed to be off at this time. I have to run 1 minute.
Right.
What I said doesn't lead to the conclusion Lawyer Abdullah is reaching. No. We are citizens, right? We can also look at there's a court, in one word, the court of public opinion. So the court of public opinion holding a certain opinion doesn't mean that the court cannot do its work. So it's not an attack on the court.
Okay, we seem to have lost Lawyer Martin People there. Obviously, unfavorable network connections. But let me yield to you, Lawyer Kwemka, the point you were raising earlier about what the possible outcome will be, the fact that it's going to be leading to one main conclusion. Lawyer Abdullahi has a different position on that matter. He says that let's wait. At least you never know, something else could come out.
Lawyer Abdullahi is entitled to his opinion, but sometimes you look at the processes leading to where we are now, and then where we are, and you can make your own conclusions, and one will also be entitled to that. Look, if you carefully watch the process, and I'm not commenting on the merits of what has happened, never at all. First of all, you recall that the chairperson of the committee was challenged. The Chief Justice challenged the chairpersons of the committee's inclusion on the basis that even at the earlier matter, one of the matters that led to the petitions that we've had now, she sat on the matter with the learned Justice of the Supreme Court, Justice Gabriel Pwaman. She stated that. She challenged that a number of times, and it didn't work out for her. And then also, curiously, the other Justice of the Supreme Court was there. About a few days before the committee's list came out, it was part of the panel that was supposed to look at the interlocutory application made by the Chief Justice. And curiously, he was absent. And 2 days after that, the list was out, and his name was there. Very curiously. And I'm just leaving that. I'm not coming to any conclusion at all. Then look at the other members. Persons of integrity, yes. But some of them, you will know their political leaning by who they are. You just know their political leaning and all that. So I'm saying that if you look at the process, all the way through to the appointment of members of the committee and the personalities who are there, excellent persons in their own right, and etc. But look at their political and ideological orientation. And you know that life is not run through a straitjacket.
Yeah, but you agree. You've been to the Supreme Court all the time. All these judges have their own political ideologies. You know that.
Yes, absolutely. They have their ideologies. And I know, I mean, if you read all the cases, look, sometimes, let's be very frank. The justices of the Supreme Court, they use the law to do their work all the time. They don't do politics when they are doing the law. But you see, they set out principles to achieve a certain result. And if you look at the justices, the majority of them, anytime there is a political issue before them, there is a way that each of them votes, and they go ahead to defend the position they are taking. Go and look at the various justices.
Yeah, but when you raise that point, many will challenge you to that, that what's before the committee now is not a political question, is it?
Yes, it may not be a political question, I agree with you. But I'm saying that there is a certain orientation that each judge has. And they are human beings. They are not angels who are seated high up in heaven. So they are human beings, and there's a certain orientation, each of them, ideological orientation that they each have. And I'm saying if you look at the current composition, the circumstances surrounding the selection of the individuals, and then named individuals in their own right, I'm saying they are excellent personalities, but they have a certain leaning in their history. And that one is of public knowledge. You don't need to debate about it. So if you look at where everything has moved all the way till this time, the establishment of the prima facie case and etc. now has been brought to these people, and His Excellency the President has brought it to the committee. I am saying that without prejudice to any decision that they are going to take, I shudder to think about any decision to vindicate the Chief Justice. I shudder to think about it. And I am afraid I have to agree with what the learned Okujeto has said. The learned senior Okujeto has said that, in fact, and indeed, the road has come to an end.
What do you say to individuals who criticize the Chief Justice of fueling this perception that this is a political or a partisan matter before the committee? Look at her legal representation, for instance. It's been quite an interesting list. Two former, attorney generals, one of whom you've worked with. They are the ones representing her.
Okay, so before you come to that conclusion that you have stated, flip it the other way around. Who are the lawyers of the petitioners?
Yeah, but it doesn't take away my question. It's not a matter of conclusion. I'm asking about the perception.
Of the other side are renowned personalities who have represented the NDC in most cases all their lives. The only person there who may have done cases for both NDC and MPP is the learned Sadio Sorry. But even then, if you look at his posturing in the last few years, and etc., you also find a certain leaning of him. Even though I can attest to the fact that he's had the opportunity to represent both sides in cases and etc. But what I'm saying is that if you look at both sides, if you look at what the CJ, those who are representing the CJ, and look at those who are representing the other side, then clearly, even though it's a contest of legal ideas, you can come to the conclusion there is a contestation of politics. You can come to that conclusion on the basis of the representation that we have. And it will be within your own right to do so. That's why I am saying that on the basis of all that and putting all that together, along with all the pieces of evidence and the happenings all the way to the formation of the committee, one result only is expected.
But just to put on record that Oliver Barker-Vormawor has never said he's been a member of the NDC.
No, but my brother, there are two different things. Professing to be a member and not professing to be a member by your conduct and actions, you are a member.
Yeah, but you're forcing him. You're forcing him to join that family.
There is no scintilla of evidence to show that Oliver Barker-Vormawor has had any sympathies or supported the New Patriotic Party either by words or by actions.
And we do not have any evidence to say that Barker-Vormawor is a member of the NDC.
I'm saying that by his actions and sometimes his utterances, he leans towards that party. There's no dispute about it. And we should not, one of the problems that we have as a nation is that we play the ostrich. When the obvious is there, we want to debate. It's not debatable. By conduct and by utterances, I can come to the conclusion that Oliver Barker-Vormawor is NDC. I'm not afraid at all to come to that conclusion. He's a fine brain. I mean, one of the fine young legal brains, no doubt about it. But there's no doubt about the fact also that his conduct by way of utterances and actions show that he leans towards the NDC and not the NDP. So let me take all that into consideration. Yeah. If you take that all that into consideration, we'll come to the conclusion that yes, both political parties have representation and interest in the matter with respect to the CJ and then the petitioners for that matter. So we are set to arrive at a decision, even though it was not supposed to be political. People will read political meanings into it all in the end because of the circumstances of the matter as a whole. Right.
Justice Abdullahi, how do we douse that flame of partisanship that may creep into the judiciary based on the observations we're making now?
Unfortunately, we are already here, and but we can naturally work towards gradual removal of the partisan inroads into the judiciary by finding a better means of appointing members of the Superior Court, such that their heads could also be appointed from within rather than from the executive. So long as the executive remains in charge of appointment of the Superior Court judges, I think we can never move away from this posture and this position. Let's remember that the entire appointment to the Superior Court, and just for the purpose of our listeners, when we talk about Superior Court, we mean from the High Court, the Court of Appeal, all the way to the Supreme Court. All the appointments are made by the President, and the President makes these appointments mostly not based on competence, but based on other factors that may obviously be political in nature. And so typically you would not find that a person is being appointed to the judiciary on the basis of his competence. Few times, yes, other people make the list that they make those lists purely because of their competence. But that is not the basis for the appointment. Let's remember that. And so my position is that if we could allow and institute a new measure that would enable appointments to the Superior Court to be handled outside of the executive and indeed outside of the political realm, I think we would have achieved the best for our republic. And having said that, I think that same argument goes for most of our political and indeed, if you like, constitutional bodies. because most of our constitutional bodies suffer from these same political interferences, and political interferences have gone against all of us in a lot of ways. In fact, it's possibly part of the reasons why we have, institutional inertia sometimes when we need to make headway, but because of political interest, we are unable to take the appropriate decisions to move our country forward, and we are always backwards for a lot of reasons. And so, yes, we have the Judicial Council, and that council can be, for instance, empowered to take charge of.
In some jurisdictions, it's based on elections.
Hello, can you please?
In some jurisdictions, it's based on elections.
Indeed, in some countries, elections are held to elect the members. I think just a couple of weeks ago, one of the Southern American countries elected its members of the judiciary, and it was a beautiful thing. The people themselves determine how these appointments are made, and so the person does not owe, particularly when if in the light of our constitution, that says that justice really rests with the people of Ghana, and it is administered in the name of the Republic for all of us. And so, for a country that has that kind of constitutional provision, it's a constitutional provision that underlies the bedrock of the Constitution and indeed the judiciary. Unfortunately, when it comes to the appointment, we are completely removed from it. And then someone else who is politically colored does the appointment. And naturally, when that person does it, he will do it to favor his lineage, as my brother Prenga calls it. And so long as we keep having that, I don't think this spectacle of having the two political parties bantering before in the arena would be something of the past. Not until we grew maturely into a better and a well-grounded democracy.
Okay, let me give the final word to you, Dindiok Penka. Your points as we wrap up this conversation.
Well, bro, I will continue to say, and I repeat without any shred of doubt, that we have reached the end of the road almost. And all we need to do is to keep our fingers crossed. But the danger, I have said time and again, is that we should be mindful, because precedence is a very dangerous monster that can eat up a society. Whatever happens today, somebody may stand on top of the roof and clap that the process is being followed. When the tables turn, the same person will have adverse statements to make. Let's hasten slowly and allow the independent institution like the judiciary, the third arm of government, to function without interference. When we politicize it and take decisions that will satisfy us today, posterity will live to judge all of us. Because this will be the very first time in our recent history that a Chief Justice is removed, if indeed the committee goes ahead and recommends removal and His Excellency the President appends his signature. That will set a precedent. All right. And I repeat that precedent may be a monster that will eat us tomorrow.
Okay. Grateful. Dindiok Penka is a former Deputy Attorney General joining the conversation. Grateful to you, law lecturer and private legal practitioner, Justice Abdullahi, and also to Martin People for joining the conversation here on UPFront. I'm Blessed Sogah. We'll see you again. Until then, log on to myjoyonline.com. Many stories there for you. Thanks for watching. Bye-bye.